So on today's episode of Realtors in RVs, I have Dennis DiSabato, South Carolina real estate attorney, who's going to give you all the information that you'll need if you're relocating to South Carolina and you need some legal advice. Come on in. All right, guys, welcome back to Realtors in RVs. Guess what? No more studio for this episode. Well, we will be back in the studio, but when I have my real estate colleagues, industry professionals, I want to bring you the most knowledge that I can. We're going to be doing that right in the RV. Realtors in RVs. Brought to you by Serafina Creatives. And again, every episode will go to benefit my charitable mission, Cans and Crayons, where no child will ever be without food or without the means to create. Anyway, today's guest is the awesome Dennis DiSabato. He's a South Carolina real estate attorney, and he's on a council, but I'll let him talk about that. How are you?
I'm good. How are you? Yes.
Yeah, what council are you on? Because I can never get it right.
I'm on Horry County Council, District 3, representing Carolina Forest.
Okay, and what do you do on the council?
We basically are responsible for allocating the tax revenue for county uses. We deal with public safety issues, zoning issues, managed growth, things like that.
Oh, okay. Nice, very nice. So one of the things I wanted to do when I brought Dennis on the show is that there's a lot of knowledge that needs to be spread. I deal with a lot of relocationers. Is that what you call it? People relocating from all other states, from up north, from out west, even from North Carolina coming down. South Carolina real estate law is completely different than New York, Ohio, Pennsylvania. And I wanted to bring Dennis on the show to kind of talk about some of the things that we're running into. It's a completely different animal. I guess, are we considered a title state?
Or we're an attorney state.
We're an attorney state. Okay, so we're considered an attorney. So we are an attorney state. And Dennis, let's talk about that and how this is different. Let's bring New York into the picture, because I have a lot of clientele from New York. How is the difference between South Carolina and New York real estate law?
It's very, very different. I practiced law in New York, as you know, for a number of years before I came here, and New Jersey as well. And the practice of real estate law is very different here than it is up there. I mean, in New York, when you're handling a closing, every single party is represented by a different attorney.
Yeah.
You've got the buyer, the seller, the title company is separate from the attorney's office. You've got the bank and the bank's lawyer, and everybody's sitting at the table at the same time, and they're marking up contracts and they're passing checks and keys around, and it's just it's a little bit more contentious, I guess, maybe, or guarded. I prefer the practice of real estate here in South Carolina is a little bit more easygoing. Not that we're not diligently representing our clients' interests. It's just it's not as combative, I guess, as it is in New York. And the difference here is, a lot of people come from what are called title states, where you don't actually need an attorney to handle a real estate closing. You just need a title company. And they're searching the title and issuing the title insurance policy and things like that. But here in South Carolina, the legislature has determined that the closing of a real estate transaction is to be considered the practice of law. And so you need to have an attorney involved in the transaction. And oftentimes the attorney and the title company are one and the same, as that's the case with us at Blair Cato. We have our own title company, and we are both searching the title, reviewing the contract, handling the closing, issuing the title policy, dispersing the closing proceeds, recording all the insurance that need to be recorded. So, in this state, you need to have an attorney involved in the process, and you have to have a South Carolina licensed attorney involved in the process. So you can't just bring in an attorney from another state and say, "Let's do a closing." They have to be authorized to practice law here in South Carolina.
Yeah, that's one of the things that I feel that we get, is that people want to bring their own attorney from a different state, not realizing that your attorney doesn't practice in this state. Like why is that? Why do people feel that the need to bring their out-of-state attorney to even review the contracts? We get that all the time.
I think it's a trust factor thing. They're not familiar with the area. They don't know the area as well, or the practice of law here. They've grown up in an area where they are familiar with the processes, and they're familiar with their attorney, and perhaps their attorney represented them over several different matters throughout the years. and now they're coming to a new location and they're being introduced to somebody that they've never met before. So there's a trust factor that needs to be built between the attorney and the client, and of course the realtor and the attorney and the client, that triumvirate. But at the end of the day, really, the other thing that's different about South Carolina law, especially in the real estate field, is that almost every jurisdiction in South Carolina uses a South Carolina approved form contract.
Yes.
Whereas in New York, a lot of times the attorneys will be the ones who draft the contracts.
Yes.
And that's not the case here. Here there's a one form contract. Everybody uses the same contract, and the attorneys don't review prior to closing. They are responsible for making sure that the contractual obligations that were negotiated in that contract are met. They're responsible for making sure that the title is clear, but they're not responsible for drafting the contract. And so a lot of times I find that my clients that come from, especially New York and New Jersey, they have a hard time wrapping their mind around that concept that this contract, your contract is going to look identical to the guy who comes in behind you, right? So the only things that are different are the items that you're negotiating you're basically checking boxes, right?
Right.
Filling in the terms of the price, you're filling in the address, you're determining who's responsible for certain due diligence items. And those are more or less just check boxing, box checking issues. And then, the attorney's just making sure that everything that is on that contract each contingency gets met.
Right. Now, one of the things too that was very new to me is that here we can share an attorney. So I remember when I first bought my condo here and they said, "Oh, do you want to share an attorney?" I'm like, "Share an attorney? No way." I go, "I need my attorney to fight for me." I didn't realize that was a commonality. A lot of people do it here, right? Share an attorney.
Yeah, well, actually, Horry County is unique in that it doesn't happen as often as it does throughout the rest of the state. We have our firm has offices throughout the upstate, Midlands, and now on the coast. So you see in other jurisdictions like Columbia or Greenville, it's much more common for both the buyer and seller to be represented by the same attorney. It's a little less common here. It's becoming more common. It's not. There is potentially a conflict of interest that is waived by both parties when you're doing that. Now, at the end of the day, the seller's attorney's role is a little different than the buyer's attorney role. And the seller's attorney's role in a real estate closing is basically to, again, make sure that the contractual obligations and contingencies have been met. They're responsible for, helping their client navigate the process and answer any questions that they have about the closing process as we get to the closing. And the seller's attorney is typically the party that's responsible for drafting the deed, not recording the deed, but drafting the deed.
Right.
And the buyer's representation is a little bit different in that the buyer's attorney is searching the title. If there's any curative issues that need to be done, a lien that was supposed to have been satisfied years ago and never did, the buyer's attorney is responsible for working with the seller's attorney to help address those curative issues. They're making sure that all the contingencies are met in the contract, and then at the end of the closing, after everything's been executed, the buyer's attorney is also responsible for recording any instruments like the deed or the mortgage, and then dispersing all the closing proceeds out of the trust account. Real estate doesn't need to be contentious here.
Right.
So a lot of times it's just a more efficient process to let one attorney handle both sides of the transaction.
Right.
It gets the closing done quicker without having to worry about documents getting from point A to point B so that they can be recorded in a timely fashion and things like that. The only issue that as a buyer or seller I would be concerned with is what happens if there's a dispute between the parties and the same attorney represent both parties. Well, it's not an issue really, because most attorneys who practice in the real estate field here don't litigate. Right. So at the end of the day, the attorney that represented you as a buyer or as a seller is going to end up handing you off to an attorney that litigates matters anyway if there's a dispute. Right. So the only difference here is that if I'm representing both parties, I can't give advice to either one as it pertains to that dispute, because I have information that's valuable to both of them. And so I would just basically tell that client, look, I understand that you have an issue that you feel like you need to address, and I encourage you to do that, but here's the name of an attorney that I think you should call and help with that. So, there's not usually, look, we do thousands of transactions a year. can count on one hand each year how many times a situation goes sideways and it gets to the point where one party feels like they need to bring an action against the other.
Right.
In fact, it's very, very rare.
It is rare here. I've noticed that too. I see it all the time in New York, but it's very rare here. All right, one question that I get all the time. Closing day is on a Thursday. I just drove 5 hours to get to my closing. I closed at 10 o'clock in the morning. I cannot have the keys to my house until 2, 3 o'clock, until my deed is recorded. Table funding, right? Is that what it's called?
So
let's explain that to people, Dennis.
So there are, table funding means that when the buyer's attorney is in receipt of all the originally executed documents, including the deed, and all the funds coming in to be dispersed at the closing, including their client's funds, the earnest money, and the funds coming from a lender if there is one. Once the attorney is in receipt of all of that, then the buyer can have access to the property, and the sale proceeds will be released to the seller, even if we don't wait for a recording of the deed. And so we table fund at Blair Cato. A lot of older firms don't. They say we're not going to disperse any money until the deed's recorded. That is the opposite of table funding. Now, I think that's silly, and the reason why is because this is a race notice state, and what that means is that the first person to record their deed is the one that puts the interest on record for the world to know. So the recording of a deed isn't really there to help certify that the closing occurred per se. It's there for the benefit of the buyer to let the rest of the world know that that property has conveyed to them. Theoretically speaking, a buyer never has to record a deed, and the closing could still occur and the conveyance still occurs. The deed is really just a notice for the rest of the world to know that, Dennis bought this piece of property. Now, race owned states like ours, if you have an unscrupulous seller, they could technically do a closing with Dennis on day one, and then several hours later do a closing with Alysia. And then if Alysia gets to the courthouse before Dennis and records her deed, then Alysia has the property. So that it's really there to protect me as the bona fide buyer.
Right.
And so, our position is like, if we have all the money and the property is insured and there's gap title insurance coverage and we have the document, it's in a position to be recorded, you can have your money and you can have the property, and we'll go ahead and the formality of recording the deed can happen after.
Yeah. Because when I first bought my condo 4 years ago and we moved down here, we had driven here, and it was the Friday of Memorial Day weekend, and we closed, and I could not get the access to my new home for hours. So we had to drive around. We decided to go buy the furniture, go out to lunch, and then we kept calling our realtor, like, can we get in? No, not yet, Alysia. Nobody called me. And then it was like 4 hours later we got the call. You can go in now.
Yeah, a lot of times you'll find with builders, particularly like new construction homes.
Oh, this is on my condo.
Oh, okay.
4 years ago. Yeah, with my new construction, I got right in. Yeah.
Yeah. The builders will usually just want to make sure that the money has been transferred to their attorney's trust account before they'll give you the keys. Yeah. And it happens from time to time. We had a mail away closing several months ago, and the package was delayed as a result of the snowstorm.
Oh.
And so, this guy closed in Chicago, on a Wednesday or a Thursday. They mailed the package to us. It never came to us on Friday when it needed to be recorded. He was driving down from Chicago and expected to get into the home over the weekend. And, luckily we had a scanned copy of the package that was sent to us by the mobile notary. And so, we were able to get permission from the seller for him to occupy the property.
Perfect. Yeah.
And so, was just the formality waiting for the documents to come so we could record and disperse on Monday.
Yeah.
But yeah, these things happen, but there's always ways to navigate around.
Yeah. And I hope during this episode that we're not talking jargon that nobody would understand. So if there's a word or something that you didn't understand, just comment below on, in the comments or whatever, or give me a call, 833-TOP-HERO, and we can personally set up a call with Dennis from Blair Cato to kind of walk you through the next steps of purchasing a home in South Carolina. But I say the name, you're wearing the name of the shirt, and I received this package from Blair Cato, and it came with a card, and as you can see, it has a unicorn, and it said, "Congratulations, you're a unicorn. You're the top 1% of agents in the area." It was so beautiful. I don't have the card on me, but let's talk about the unicorn. And thank you so much for
You're welcome.
for your company recognizing the hard work that realtors put in.
So the Unicorn Collective is a program that we have started at Blair Cato about a year and a half ago, and we wanted to recognize the agents in the industry that really go out of their way to help buyers find new homes. So if you are a top 1% buyer agent in your MLS, you are automatically enrolled in Unicorn Collective, whether you refer business to Blair Cato or not. And what it does is it provides you with a number of different incentives, in addition to some really cool gifts and swag that we sent to you with the unicorn branding. It gives you things like priority scheduling on our closing calendar. It gives you additional educational benefits that you can utilize for CE. You have your own email address with the firm that you can escalate matters directly to a partner level employee.
I get all this with the unicorn?
You get all of this.
Oh, I thought I just got this great water bottle and this chenille blanket.
No.
Oh, so wow, this is great.
We'll even provide business planning services for you.
Get out of here.
Yeah. So there's a lot of really cool benefits. but you know, it is limited to 1% buyer agents.
Okay.
But there's a good number of you guys out there. So. And this is an incentive for those of you who are close to strive for that.
I know. I love it. I absolutely love it. Dennis and I have done more than a handful of deals together over the past, I guess, 3 years, 3.5 years. So Blair Cato, guys. Now, if somebody wanted to get in touch with you, Dennis, how would they?
Sure. My direct dial at the office is 843-919-0989. I get you past my receptionist directly to me. My email address is Dennis with 2 N's, DENNIS at blaircato.com, BLAIRCATO.com.
Okay.
And we'd love to work with you. We'd love to have an opportunity to show you what we do. We're really unique at Blair Cato with our closing day experience. It's really, I think, what sets the firm apart from other firms. When you come to our office, first of all, it's gorgeous. Very modern, very welcoming. You come in, you get warmly greeted by our receptionist. There's a million snacks or drinks you could choose.
I'm going to vouch for that because I get coffee and snacks every time I'm there. They have like the best collection and the best assortment of snacks.
And then we even have our own beer.
Oh, that's right. You do. Yes.
It's called Closing Time Beer. So if you want to have a beer or champagne cocktail to celebrate the purchase of the home, we'll offer you something to drink. And then when you're actually in the closing room, we have an iPad set up for you so that you could select the kind of music you want to listen to while going through the execution of the documents, and beautiful slideshow presentation on the screen showing a picture of the house and welcoming you to the community and thanking the agents and the lenders who are involved in the transaction for all of their hard work. And then we got the fun props you could take pictures with when the closing's completed and all that. So we just really, and I take a lot of time with the closings, explaining documents to clients. I'm not one of those attorneys that's just going to slide a paper in front of you and say, sign here, sign here. So, we really, we take that experience to the next level just to show you, this is usually the biggest transaction most people are going to commit to in their entire lifetime. So we take that seriously, and we want to make sure that it's not just a warm and welcoming experience, but we try to have a little fun with it too.
And one of the things I want to end my show with, Dennis, is I want to thank you for coming on Blair Cato.
Thank you.
I want to, I sing and dance my way through life.
Okay.
All right. So now, pick I love the 80s music.
Okay.
So pick an 80s song. Waiting.
My wife is going to laugh at me because this is sort of like from our history in dating, but I Think We're Alone Now by Tiffany.
I think we're alone now. There doesn't seem to be. Didn't she have a dance? There was a dance. There was a dance that went with that. There doesn't seem to be anyone around. I think we're alone now.
I embarrassed my wife when we first started dating by playing this on a jukebox in a bar we were hanging out in and karaoke singing it to her by myself in front of
In front of everybody. So you really weren't alone, but you just
You weren't alone at all, yeah.
Now, did you guys meet here or in New York?
No, we met here.
So Dennis is from New York.
Originally, yeah.
Yeah, so am I. We're both transplants from New York. He's been here for a lot. Your whole family is here, though.
Yeah, my parents moved down in 2001, and I followed them down about 5 years later. Okay. So I've been down here almost 19 years.
Yeah, so Dennis was in the city the day that on 9/11, the day that Chris was actually working at the NYPD when he was working that day when the planes hit, and that was Dennis's your first exam, right?
That was my first week of law school. My law school was New York Law School, which was just about 8 blocks north of the World Trade Center. It was the first exam that I had in law school, and I was late because of what was happening, and I was maybe the only idiot in the city running downtown when everybody else was running uptown. But yeah, that was a difficult day.
So do you continue to practice in New York, or no? You only have your license.
I'm sort of in a I guess a retired state. Okay. New York. I still maintain my license, but I don't practice.
Yeah. Oh, I have one more question that everybody always asks me before we go, Dennis. Okay. At the end of every closing, I've done a closing, and you have the law, the spiel, the 4% and the 6%.
Oh, yeah.
We got to talk about that because that confuses a lot of people. Like, we cannot end. That's how we're going to end the show, with 4% and 6%. Take it away.
Okay.
Give the facts.
So in South Carolina, the default tax assessment rate on all real property is 6%. You get taxed at a 6% assessment ratio. But in South Carolina, under a law called Act 388, if you're using that property as your primary residence, you get to apply for what is called a legal residency exemption, which will reduce that assessment ratio from 6% down to 4%. And it doesn't sound that would make a big difference, but it can save you literally thousands of dollars on real property taxes every year. And then on top of that, if you are over the age of 65 and have lived in the county for a year, or if you're a disabled veteran, you also get the opportunity to apply for what's called a homestead exemption. And the homestead exemption takes $50,000 off of the assessed value of the property prior to any tax calculation. So you'll have that reduction of $50,000 plus the 4% assessment ratio will save you a lot of money in taxes. So it's important that when you buy your home, you're aware of this, that you go and make that application as soon as possible. Because you can, if you don't do that, a lot of times, especially if you have a mortgage, your lender is calculating your tax escrow at the 4%. And if you fail to make the application and they tax you at 6%, you can end up with a nasty gram from the lender saying, we haven't collected enough money in escrow, and here's how much money you owe us. And it's always fixable. It even happened to me, and I'm a real estate lawyer. I forgot to make my application when I bought my home. Okay. You can always go back. You have, I think, 2 years to make the application, and then they'll rebate you the amount of money that you overpaid. Mm-hmm. But it's more difficult to unwind it than it is to just take care of it up front. So if you ever have questions about how taxes are assessed, obviously give Alysia and myself a call to navigate that process for you.
Yep, that's right. Well, thank you, Dennis DiSabato of Blair Cato.
Thank you.